Good day, everyone. I am Roslyn Megan Acosta, and I will be reporting about the patents and trademarks under the Intellectual Property Code, or also known as Republic Act 8293. It is an act prescribing the Intellectual Property Code and establishing the Intellectual Property Office, providing for its powers and functions and for other purposes. So I know that we have all heard copyright, trademarks, and patents. So just a quick summary about the differences between copyright, trademarks, and patents. Copyright is an original intellectual creations in the literary and artistic domain. Trademarks are any visible sign capable of distinguishing the goods. Patents, a product, process, or any improvement thereof which is a technical solution of a problem. A patent is a grant issued by the Intellectual Property Office of the Philippines, also known as IPOPHL. Through the patent, a patent holder is given the exclusive right to exclude others from making, using, importing, and selling the patented innovation for a limited period of time. A patentable invention is any technical solution of a problem in any field of human activity which is new, involves an inventive step, industrially applicable, shall be patentable. It may be or may relate to a product or process or an improvement of any of the foregoing. The electric light bulb is perhaps one of the most patented inventions known to humankind. It was awarded to Thomas Alva Edison in the year 1878. However, an English inventor called Joseph Swan had received a patent for a similar product in England at the same time. Later, the two joined hands to form Edison and Swan United Electric Light Company. Another example is the first telephone, which was invented and patented by Alexander Graham Bell in 1876. Bell is also a co-founder of the American Telephone and Telegraph Company, also known as AT&T. Later, the company expanded to control all telecommunications and become the world's most significant in the industry. The following shall be excluded from patent protection: discoveries, scientific theories, and mathematical methods. In the case of drugs and medicines, there is no inventive step if the invention results from the mere discovery of a new form or a new property of a known substance which does not result in the enhancement of the known efficacy of that substance. Second, the mere discovery of any new property or new use for a known substance, or the mere use of a known process unless such known process results in a new product that employs at least one new reactant. The term of a patent shall be 20 years from the filing date of the application. The right to a patent belongs to the inventor, his heirs, or assigns. When two or more persons have jointly made an invention, the right to a patent shall belong to them jointly. The first to file rule is when two or more persons have made the invention separately and independently of each other. The right to the patent shall belong to the person who filed an application for such invention, or where two or more applications are filed for the same invention, to the applicant who has the earliest filing date or the earliest priority date. Invention created pursuant to a commission. The person who commissions the work shall own the patent unless otherwise provided in the contract. So if an employee made the invention in the course of his regular employment, the patent shall belong to first the employee if the inventive activity is not part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. So the patent shall also belong to the employer if the invention is the result of the performance of the employee's regular duties unless there is an agreement to the contrary. Right of priority. An application for patent filed by any person who has previously applied for the same invention in another country, which by treaty, convention, or law affords similar privileges to Filipino citizens, shall be considered as filed as of the date of filing the foreign application, provided that the local application expressly claims priority. It is filed within 12 months from the date the earliest foreign application was filed, and a certified copy of the foreign application together with an English translation is filed within 6 months from the date of filing in the Philippines. Grounds for cancellation of a patent. Any interested person may, upon payment of the required fee, petition to cancel the patent or any claim thereof, or parts of the claim, on any of the following grounds. First, that what is claimed as the invention is not new or patentable. Second, that the patent does not disclose the invention in a manner sufficiently clear and complete for it to be carried out by any person skilled in the art, or that the patent is contrary to public order or morality. Remedy of the true and actual inventor. If a person who was deprived of the patent without his consent or through fraud is declared by final court order or decision to be the true and actual inventor, the court shall order for his substitution as patentee or at the option of the true inventor, cancel the patent, and award actual and other damages in his favor if warranted by the circumstances. The remedies of the true and actual inventor are substitution as patentee and cancellation of the patent. In both remedies, damages may be awarded, but there must first be a final court order declaring that he is the true and actual inventor. Rights conferred by a patent. Where the subject matter of a patent is a product, to restrain, prohibit, and prevent any unauthorized person or entity from making, using, offering for sale, selling, or importing that product. Where the subject matter of a patent is a process, to restrain, prevent, or prohibit any unauthorized person or entity from using the process and from manufacturing, dealing in, using, selling, or offering for sale or importing any product obtained directly or indirectly from such process. Rights of joint owners. If two or more persons own the patent and invention covered thereby, each of the joint owners shall be entitled to personally make, use, sell, or import the invention for his own profit, provided neither of joint owners shall be entitled to grant licenses or to assign his right, title, or interest, or part thereof without consent of other owner or owners, or without proportionally. The patentee has no right to prevent third parties in the following circumstances: using a patented product which has been put on the market in the Philippines by the owner of the product, or with his express consent, insofar as such use is performed after that product has been so put on the said market, where the act is done privately and on a non-commercial scale, or for a non-commercial purpose, and the economic interests of the patentee are not significantly prejudiced, where the act consists of making or using exclusively for experimental use of the invention for scientific purposes or educational purposes and such other activities directly related to such scientific or educational experimental. In the case of drugs and medicines, where the act includes testing, using, making, or selling the invention, including any data related thereto, solely for purposes reasonably related to the development and submission of information and issuance of approvals by government regulatory agencies required under any law of the Philippines or of another country that regulates the manufacture, construction, use, or sale of any product, where the act consists of the preparation for individual cases in a pharmacy or by a medical professional of a medicine in accordance with a medical prescription or acts concerning the medicine so prepared, and where the invention is used in any ship, vessel, aircraft, or land vehicle of any other country entering the territory of the Philippines temporarily or accidentally. Patent infringement consists of the following acts: making, using, offering for sale, selling, or importing a patented product or a product obtained directly or indirectly from a patented process, or use of a patented process without the authorization of the patentee constitutes patent infringement. Test in patent infringement. Resort must be had to the words of the claim. If accused matter clearly falls within the claim, then there is a literal infringement. Under the doctrine of equivalence, there is still patent infringement when there is an appropriation of the inventive step of a prior invention. The subsequent invention has been modified or changed, and despite such changes, the subsequent invention performs substantially the same function in substantially the same way to achieve substantially the same result. Criminal action for repetition of infringement. Imprisonment for the period of not less than 6 months but not more than 3 years, and or a fine of not less than 100,000 pesos but not more than 300,000 pesos at the discretion of the court. In an action of infringement, the defendant may show the invalidity of the patent or any claim thereof on any of the following grounds: that what is claimed as the invention is not new or patentable, that the patent does not disclose the invention in a manner sufficiently clear and complete for it to be carried out by any person skilled in the art, or that the patent is contrary to public order or morality. To encourage the transfer and dissemination of technology, prevent or control practices and conditions that may constitute an abuse of intellectual property rights, having an adverse effect on competition and trade, all technology transfer arrangements must comply with the provisions of the IP Code. Assignment and transmission of rights. An assignment may be of the entire right, title, or interest in and to the patent and the invention covered thereby, or of an undivided share of the entire patent and invention, in which event the parties become joint owners thereof. An assignment may be limited to a specified territory. The assignment must be in writing, acknowledged before a notary public or other officer authorized to administer oath or perform notarial acts, and certified under the hand and official seal of the notary or such other officer. Requirements for recording of assignment. It must be in writing and accompanied by an English translation if it is in a language other than English or Filipino. It must be notarized. It must be accompanied by an appointment of a resident agent if the assignee is not residing in the Philippines. It must identify the letters patent involved by a number and date, and give the name of the owner of the patent and the title of the invention. It must be accompanied by the required fees. The next topic is trademarks. What are trademarks? They indicate origin or ownership of the articles to which they are attached. They guarantee that those articles come up to certain standard of quality, and they advertise the articles they. Definitions of marks, collective marks, and trade names. Mark is any visible sign capable of distinguishing the goods or services of an enterprise and shall include a stamp or marked container of goods. Collective mark, any visible sign designated as such in the application for registration and capable of distinguishing the origin or any other common characteristic, including the quality of goods or services of different enterprises, which use the sign under the control of the registered owner of the collective mark. Trade name, any name or designation identifying or distinguishing an enterprise. A name or designation may not be used as a trade name if, by its nature or the use to which such name or designation may be put, it is contrary to public order or morals. It is liable to deceive trade circles or the public as to the nature of the enterprise identified by that name, or it is similar to a mark or a trade name owned by another person, and its use would likely mislead the public. Here are some of the examples of trademarks. The golden arc that symbolizes McDonald's, Nike's swoosh, and the apple by the apple itself. So it could be a logo or a slogan, or a logo and a slogan. Trademarks can also be a product shape, such as the triangle shape of the Toblerone chocolate and the Coca-Cola bottle. Doctrine of secondary meaning. A word or phrase originally incapable of exclusive appropriation with reference to an article in the market might nevertheless have been used for so long and so exclusively by one producer with reference to his article that in the trade and to that branch of the purchasing public, the word or phrase has come to mean that the article was his property. A certificate of registration shall remain in force for 10 years, provided that the registrant shall file a declaration of actual use and evidence to that effect, or shall show valid reasons based on the existence of obstacles to such use as prescribed by the regulations within 1 year from the fifth anniversary of the date of the registration of the mark. Otherwise, the mark shall be removed from the register by the office. A certificate of registration may be renewed for periods of 10 years at its expiration upon payment of the prescribed fee and upon filing of a notwithstanding any laws or regulations providing for any obligation to register trade names, such names shall be protected, even prior to a without registration, against any unlawful act committed by third parties. In particular, any subsequent use of the trade name by a third party, whether as a trade name or a mark or collective mark, or any such use of a similar trade name or mark likely to mislead the public, shall be deemed unlawful. A mark cannot be registered if it consists of immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest a connection with persons, living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute. Consists of the flag, or coat of arms, or other insignia of the Philippines, or any of its political subdivisions, or of any foreign nation, or any simulation thereof. Consists of a name, portrait, or signature identifying a particular living individual except by his written consent, or the name, signature, or portrait of a deceased president of the Philippines during the life of his widow, if any, except by written consent of the widow, is identical with a registered mark belonging to a different proprietor, or a mark with an earlier filing or priority date in respect of the same goods or services, closely related goods or services, or if it nearly resembles such a mark as to be likely to deceive or cause confusion, is identical with or confusingly similar to or constitutes a translation of a mark which is considered by the competent authority of the Philippines to be well known internationally and in the Philippines, whether or not it is registered here. as being already the mark of a person other than the applicant for the registration, and used for identical or similar goods or services, is identical with or confusingly similar to, or constitutes a translation of a mark considered well known in accordance with the preceding paragraph, which is registered in the Philippines with respect to goods or services which are not similar to those with respect to which registration is likely to mislead the public, particularly as to the nature, quality, characteristic, or geographical origin of the goods or services, consist exclusively of signs that are generic for the goods or services that they seek to identify, consist exclusively of signs or of indications that have become customary or usual to designate the goods or services in everyday language or in a bona fide and established trade practice. Indications that may serve in trade to designate the kind, quality, quantity, intended purpose, value, geographical origin, time, or production of the goods or rendering of the services or other characteristics of the goods consist of shapes that may be necessitated by technical factors or by the nature of the goods themselves or factors that affect their intrinsic value, consist of color alone unless defined by a given form, or is contrary to public order or morality. Prior use of mark as requirement. Under trademark law, which is an old rule, the rights to a trademark were acquired through a first use system. Under the IP code, which is the new rule, the rights in a mark shall be acquired through registration made validly in accordance with the provisions of this law. Prior use no longer determines the acquisition of ownership of a mark in light of the adoption of the rule that ownership of a mark is acquired through registration made validly in accordance with the provisions of the IP code. The owner of a registered mark shall have the exclusive right to prevent all third parties not having the owner's consent from using in the course of trade identical or similar signs or containers for goods or services which are identical or similar to those in respect of which a trademark is registered, and where such use would result in a likelihood of confusion. The exclusive right of the owner of a well-known mark which is registered in the Philippines shall extend to goods and services which are not similar to those in respect of which the mark is registered, provided that the use of that mark in relation to those goods or services would indicate a connection between those goods or services and the owner of the registered mark, and that the interests of the owner of the registered mark are likely to be damaged by such. Registration of the mark shall not confer on the registered owner the right to preclude third parties from using bona fide their names, addresses, pseudonyms, a geographical name, or exact indications concerning the kind, quality, quantity, destination, value, place of origin, or time of production or of supply of their goods or services, provided that such use is confined to the purposes of mere identification or information and cannot mislead the public as to the source of the goods or services. A person shall be liable for trademark infringement if, without the consent of the owner of the registered mark, he uses in commerce any reproduction or colorable imitation of a registered mark or the same container or a dominant feature thereof in connection with the sale, offering for sale, distribution, advertising of any goods or services which is likely to cause confusion or to cause mistake or to deceive, reproduces or colorably imitates a registered mark or a dominant feature thereof and applies such reproduction or colorable imitations to signs, packages, or advertisements intended to be used in commerce upon or in connection with the sale, offering for sale, distribution, or advertising of goods or services which likely to cause confusion or to cause mistake or to deceive. The reasonable profit which the complaining party would have made had the defendant not infringed his rights, or the profit which the defendant actually made out of infringement. If the measure of damages cannot be readily ascertained with reasonable certainty, the court may award as damages as a reasonable percentage based upon the amount of gross sales of the defendant or the value of the services in connection with which the mark of trade name was used in the infringement of the rights of the complaining party. On application of the complainant, the court may impound during the pendency of the action sales invoice and other documents evidencing sales. A person who has identified in the mind of the public the goods he manufactures or deals in his business or services from those of others, whether or not a registered mark is employed, has a property right in the goodwill of the said goods, business, or services so identified, which will be protected in the same manner as other property. The law on unfair competition is broader and more inclusive than the law on trademark infringement. Trademark infringement is more limited, but it recognizes a more exclusive right derived from the trademark adoption and registration by the person whose goods or business is first associated with. The law on trademarks is specialized subject distinct from the law on unfair competition, although the two subjects are entwined with each other and are dealt with together in the IP code. The Madrid Protocol provides a cost-effective and efficient way for trademark holders to ensure protection for their marks in multiple countries through the filing of one application with a single office in one language with one set of fees in one currency. The Philippines acceded to the Madrid Protocol with effect on July 25, 2012. An international application may be filed only by a natural person or a legal entity having an industrial or commercial establishment in or being domiciled in or a national of the Philippines. An international mark registered under the Madrid system can be protected within the territories of state parties to the Madrid requirements for registration. An international application must be presented to the International Bureau through the IPOPHL. An international application which is presented direct to the International Bureau by the applicant will not be considered as such and will be returned to the sender. Term of protection. An international registration is effective for 10 years. It be renewed for further periods of 10 years on payment of the prescribed fees. The international registration may be renewed in respect of all the designated contracting parties or in respect of only some of them. That ends my topic. Thank you very much.